This video is going to go through the various aspects of the Office of Special Counsel, or OSC for short, that are important for you. OSC's primary responsibility is to protect federal employees and applicants from prohibited personnel practices, especially reprisal for whistleblowing. OSC's headquarters are in Washington, D.C., and the agency has several field offices, out of which investigations are conducted. There are 3 different divisions of OSC that are going to be relevant to you. First is the Complaints Examining Unit, or CEU for short. This is where complaints come when they first enter OSC. CEU does a preliminary assessment of the allegations in the complaint to determine whether a violation of law may have occurred, and then forwards the case on to either the Alternative Dispute Resolution Unit or the Investigation and Prosecution Division for further review. The Alternative Dispute Resolution Unit, or the ADR unit, is where mediations take place. Lastly, the Investigation and Prosecution Division, or IPD, is where cases go to be investigated and prosecuted by OSC attorneys.
Let's run through a few example scenarios to show you what the process actually looks like. First, CEU gets a case. After making sure the case meets certain standards, they often send the case to the ADR unit to assess if it is right for mediation. However, in some circumstances the case could go directly to IPD, but it is often vetted for mediation first. Once a case is in IPD or the ADR unit, it doesn't necessarily stay there. For a variety of reasons, cases can be sent from the ADR unit to IPD, and vice versa. Eventually, there will be an outcome, whether it be that the case is dismissed, the case is settled, or there's a finding for the complainant.
Now, within either the ADR unit or IPD, there are different potential outcomes. Within the ADR unit, parties either settle or they don't. In cases where they don't settle, this could be because one party withdrew from the mediation or for a variety of other reasons. If a case does not settle in the ADR unit, the case is sent over to IPD for investigation. Within IPD, the division will investigate the complaint further and either seek relief for the complainant or close the investigation without relief. In some cases, IPD may help the parties settle the complaint. Now we're going to go over the mediation process in a little more detail. As we've already discussed, first a case is sent from CEU to the ADR unit for an evaluation to determine if mediation is right for both parties. Mediation is completely voluntary, and both parties will be contacted and asked if they would like to participate. Then you'll go through a process called pre-mediation. Here, someone from the ADR unit will give you a call and talk to you about your case. They will go over 3 main things. First, they'll give you an overview of how the mediation process works and what to expect. Second, they'll ask you some questions about your specific case so they can make the mediation work for you. Third, they will go over a few logistics for your mediation, such as when and where. If you are open to mediation, the ADR staff will also go through the same steps of the pre-mediation process with the other party. If both parties voluntarily agree to mediate, you'll have your mediation. This is when you'll either sit down or have a phone call with the mediator and the other party to see if you can reach some sort of agreement. If at any point one party wishes to stop the process, the case will be forwarded on to IPD for investigation.
So, why go to mediation? There are a couple of reasons. First, it's a neutral process. The mediator is not on the complainant's side, and the mediator is not on the agency's side. The mediator's job is to facilitate communication between the 2 parties to help them have a productive conversation. It is often helpful to have someone neutral facilitate the process of communication because that individual can help parties look at issues from the other's perspective and can keep the conversation on a productive course. The second reason to consider mediation is that the process can be relatively fast. If it's important to you that this process wrap up quickly, mediation may be an option. Although the timeline may vary depending on the specifics of your case, mediation is generally faster than other alternatives. Third, Mediation can also be very efficient. Because you'll be able to speak with the other party directly, you can work through the different aspects of the case much more efficiently. Fourth, and finally, mediation can lead to some unique solutions to the case and to the issues between the parties. The two parties can be as creative as they want in coming up with solutions that meet their interests. In conclusion, although this video only summarizes some reasons why mediation might be right for you, we hope that when considering OSC mediation, you remember that it offers a neutral third party to facilitate communication, that mediation can be more expedient and efficient than other alternatives, and finally, that mediation can help you and the other party work toward creative solutions.